This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why a court must affirm the intent of the insured and the insurer as written in its contract, and that why a person has no right to UM or UIM coverage if he or she is not an insured. Now, usually when you get denied a motion for summary judgment, parties will try a writ to get a court of appeal to order the trial court to grant the motion for summary judgment, and those writs are denied with impunity by most courts of appeal, but not always. The Louisiana Court of Appeals was asked to do what it normally would not do: determine if the trial court erred in denying a motion for summary judgment filed by Employers Mutual Insurance Company. In Lee Mallahan 3 versus Employers Mutual and many others, the Court of Appeals of Louisiana on September 27, 2023, provided a response to employers' request. The request began with an automobile accident on June 1 of 2020, when Erick Guevara drove to Mr. Mallahan's house, who was standing in the driveway picking up worms from the pavement and throwing them into the grass, only to have Guevara strike Mallahan with Guevara's truck. Mallahan alleged the pickup truck knocked him in the air and caused him to lose consciousness. Mallahan sued on April 21, 2021, and named as defendants Guevara and others, and his insurer, Employers Mutual. As the managing member and an employee of a company called Tadpole LLC, Mallahan alleged that Employers Mutual provided insurance coverage, excess coverage, umbrella coverage, or other coverage for Mallahan's damages. Employers Mutual filed a motion for summary judgment and urged that there was no uninsured or underinsured coverage available or that existed for Mallahan's injuries under the terms of the commercial auto policy or the commercial umbrella policy issued to Tadpole. The trial court ordered that Mallahan raise genuine issues of material fact and denied the motion. Employers Mutual sought a writ from the Court of Appeals to order the trial court to grant its motion for summary judgment. Reviewing the case, Employers Mutual urged that the Court of Appeal, because it made a showing that Mallahan was not an insured under the policies issued to Tadpole, that there was no genuine issue of material fact to persuade the granting of summary judgment. A genuine issue is one about which reasonable people could disagree. A material fact is one that potentially ensures or precludes recovery, affects the ultimate success of the litigant, or determines the outcome of the dispute. Because it is the applicable substantive law that determines materiality, whether a particular fact in dispute is material for summary judgment purposes, can be seen only in light of the substantive law applicable to the case. Summary judgment declaring a lack of coverage under an insurance policy may not be rendered unless there is no reasonable interpretation of the policy when applied to the undisputed material facts shown by the evidence supporting the motion under which coverage could be afforded. The extent of coverage is determined from the intent of the parties as reflected by the words of the insurance policy. For Mallahan to be insured under the commercial auto policy, he must be using Tadpole's covered vehicle that Tadpole owned, hired, or borrowed with Tadpole's permission. The undisputed facts establish that Mallahan was not using any automobile at the time of the accident. As a result, Mallahan was not entitled to UM benefits, as he would not be considered an insured for purposes of Tadpole's Employers Mutual commercial auto policy. Tadpole's commercial umbrella policy also required that to be considered an insured under the policy, Mallahan must use with permission one of Tadpole's covered automobiles that he did not personally own. The policies were clear. Mallahan was not qualified as an insured. Tadpole was the named insured. Furthermore, Mallahan was not using a covered auto with Tadpole's permission when the accident occurred. In fact, no use of a vehicle was involved on Mallahan's part. Instead, Mallahan was just standing in his driveway throwing worms into the grass when Guevara's Chevy truck came into contact with Mallahan's person and threw him into the air. Employers Mutual's policies clearly define who was considered an insured under the policies and who was entitled to UM coverage. A contrary interpretation of the policy language would be unreasonable. The Court of Appeals concluded that the policies must be enforced as written. As a result of its analysis, the Court of Appeals concluded that Employers Mutual's WRIT application needed to be and was granted. The trial court was ordered to grant Employers Mutual's summary judgment motion and to dismiss Mallahan's claims against Employers Mutual. In my opinion, contracts of insurance are interesting documents. They tell the parties to the contract what will happen in the event of an injury to an insured, who is an insured, and what benefits were available. Mr. Mallahan was severely injured, and we're concerned for his injuries. But when he, as a pedestrian standing in his own driveway, proved that he was not an insured of Employers Mutual, and therefore was not entitled to UM or UIM coverage. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll gain 5, sometimes 6 videos and 6 blog postings a week, and you will have access to the more than 4,600 blog postings. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and the videos. It costs nothing. And if you really want additional information about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my locals community or my Substack publications. Thank you for your attention.